Welcome to this episode of the Diary of a Lawyer. And today we are going to be talking about Adidas and its current, now reportedly withdrawn complaint in relation to a trademark issue against the Black Lives Matter movement. Now, before we go into the actual case details, I think it's could be helpful to have just a brief background of who actually of just the background of Adidas is. Now, Adidas is a German multinational corporation that was founded and headquartered in Herzogenaurach, Bavaria. I hope that's pronounced properly. And it designs, as everybody knows, and manufactures various sports wear, shoes, clothing, and accessories. And according to public records, it's largest in Europe and I think second in the world, second only to Nike. It's also the holding company for the Adidas Group, which has a stake in Bayern Munich, according to public records, and Rutansic, which is an Austrian fitness technology company. Adidas's revenue is over the years is listed in billions. We won't go into the specific details, but it's a huge amount. And as we know, recently they had to cut um, their relationship with a very well known American artist. Let's just say that the for obvious reasons, for various reasons. Um, um, and we not get into the sides of back and forth. And the company was started by Adolf Dacier and was later joined by Rudolf, his brother, around 1924. And he was under the name Gebrud Dacier Schifferbrück, again, if pronounced properly, which loosely translated Tesla Brothers Shoe Factory in English. It has over the years, over the decades, manufactured running shoes and multiple athletic events and the development of other athletic events and sports. Um, it is reported that this year, the founder of Adidas persuaded US sprinter Jesse Owens to use his Adidas's handmade spikes at the 1936 Summer Olympics, and um, which, as you know, Jesse Owens um, is very um, an instrumental historical figure in that regard. And in 1949, the relationship between the two brothers um, disintegrated, and his brother Rudolf established Puma, which in itself is a well-known brand, arguably successful in its own right. Now, the three stripes are Adidas identity mark, and they have been used on the country's products for a very long time. It is again reported, according to public records, that he bought the three stripes from a Finnish sports company for a very meager amount of money, and which, as we all know, has since become very, very successful. Which now brings us to the case of Adidas and the Black Lives Matter. So, based on public records of its filing in the United States Patent and Trademark Office, um, which is being had before the trial, was going to be considered before the trial, before the Trademark Trial and Appeal Board. Adidas reportedly starts off saying that there's no issues to priority, uh, where the in terms of when um, Black Lives Matter started using the three stripes, and it says verbatim that there's no issue as to priority. Adidas began using the three stripes mark in commerce in connection with footwear, apparel, accessories, and related goods and services well prior to applicant's November 6, 2020 filing date and any claim date of first use. I'm reading verbatim. Consumers familiar with the goods and services long associated with the three stripe mark are likely to assume that the goods and services offered under applicant's mark originate from the same source, or that they are affiliated, connected, or associated with or sponsored by Adidas. Essentially saying people will associate the three stripes of Black Lives Matter with Adidas. It goes on to say that the applicant's mark as shown in the application incorporates three stripes in a manner that is confusingly similar to the three stripes mark in appearance and overall commercial impression. It adds that the goods and services identified in class 18, 25, and 35 of the application are identical or highly related to the goods and services Adidas has long offered in connection with the stripes mark. It um, goes on to add, in conclusion, that the registration of the Black Lives Mark in classes 18, 25, and 35 is likely to dilute the effectiveness of the three stripes mark by eroding consumers' exclusive identification of the mark with Adidas and otherwise lessen the capacity of this three stripes mark to identify and distinguish the goods and services of Adidas in violation of Section 43, subsection C, subsection 1 of the Lanham Act, 15 USC, column 1125, subsection C, subsection 1. Essentially, they're saying that it will be in violation of the relevant US law. So that is the actual filing. But since then, um, uh, media reports have indicated shortly before we came on this podcast that Adidas has backtracked, and a spokesperson is quoted as saying Adidas will withdraw its opposition to the Black Lives Matter Global Network Foundation's trademark application as soon as possible. Um, and they have not given an official reason from the records we've seen as to why they're doing that. But the overall speculation and understanding is that they have recognized that this may be a PR disaster for Adidas, because it will be seen as opposing a genuine movement that was born, or at least made propelled to global attention as a result of the sad killing of George Floyd's in Minneapolis, Massachusetts, that led to protests all around the world, and the attention brought in by the Black Lives Matter movement, that is now a loose organization all over the world. And so that's sort of the context around it. And also, I should add that the timing is very was very unfortunate for Adidas, because the current conversation in the public spheres around reparation. We've seen the Vice President, Kamala Harris, in Ghana, herself from the father's side, a descendant of slaves, standing at the site where millions over the hundreds of years were kidnapped, murdered, tortured, raped, and others transported to either the Caribbean or South America or other parts of the world or America as slaves, people of African descent. And Black Lives Matter is associated with dealing with the residue and the injustices that spring from centuries of racism and racial injustice towards people of African descent, whether that's slavery, um, colonialism, institutional racism, and the various inequalities that spring from that. We've also seen The Guardian admit publicly that the founders were benefited from slavery through the cotton trade, and they have since issued various remarks around that and saying that they will be paying reparations in one way or the other. And so the timing of being seen to oppose a movement that addresses that sort of issue would be a PR disaster for Adidas. In fact, The Guardian has a special series called The Cotton Capital, how slavery changed The Guardian, Britain, and the world, and how its founders had links to slavery. And it has since issued an apology. So that is I think, the speculation or the thinking around why Adidas has withdrawn its complaint or its opposition to the Black Lives Matter movement, which it had made to the United States Patent and Trademark Office, and office before the Trademark Trial and Appeal Board. And so there we shall leave it. But as the just I think it's important to note that the United States Patent and Trademark Office had given Black Lives Matter, I think, around 6th May, according to public records, to respond. I haven't seen any response from them yet, but if it is indeed accurate, as reported in the media, that Adidas has now withdrawn their complaint, then it's potentially, it's good news for them, and we're assuming at some point they may comment. But at the time of on this podcast, nothing had been quoted or associated with the response from the Black Lives Matter movement. So there we are. Things stand. Black Lives Matter 1, Adidas 0, and we shall leave it there and we speak again on this episode of The Diary of a Lawyer. And thank you for listening. And there we shall leave it today and we shall speak again. Thank you. Bye.